What is a qualified disclaimer, and how does it affect inheritance tax? Have you ever wondered what happens if you receive an inheritance but decide you do not want it? This is where a qualified disclaimer comes into play. A qualified disclaimer is a legal way for a beneficiary to refuse an inheritance or gift. This refusal allows the property to pass directly to the next eligible beneficiary without the disclaimant ever owning or controlling the asset. To be recognized as a qualified disclaimer for tax purposes, there are specific legal requirements that must be met. First, the disclaimer must be in writing. It should clearly identify the interest being disclaimed and be signed by the disclaimant or their legal representative. Additionally, it must be irrevocable and unqualified, meaning once it is made, it cannot be changed. Timing is also critical. The disclaimer must be delivered to the appropriate party, such as the estate representative or trustee, within 9 months of the decedent's death or the transfer that created the interest. Importantly, the disclaimant must not have accepted the disclaimed property or any benefits from it before making the disclaimer. The disclaimed interest must then pass to another person without any direction from the disclaimant. From the perspective of estate planning, a qualified disclaimer serves as a strategic tool. It helps manage the distribution of assets after someone passes away without triggering gift taxes or unintended ownership. Since the disclaimant never legally owns the property, the disclaimed assets are not considered gifts and therefore are not subject to federal gift tax. When it comes to inheritance tax, a qualified disclaimer can reduce the taxable estate of the disclaimant. By effectively removing the disclaimed property from their estate, it can help minimize estate taxes. This is particularly useful if the disclaimant would otherwise inherit property that increases their taxable estate beyond exemption limits. The property then passes as if the disclaimant had predeceased the decedent, often going directly to contingent beneficiaries or trusts established in the estate plan. Practically, qualified disclaimers can redirect assets to other beneficiaries, such as children or trusts, without incurring gift tax consequences. They also protect assets from creditors of the disclaimant, since the disclaimant never legally owns the disclaimed property. This adds flexibility in estate administration, especially when a beneficiary may not want or need the inheritance due to tax reasons, financial considerations, or personal choice. It is essential that disclaimers are made early in the estate administration process and with legal advice. This helps avoid disqualifying actions, such as accepting benefits from the property before disclaiming. If the strict timing and procedural rules are not met, the disclaimer may be invalid for tax purposes, leading to unintended tax liabilities. In summary, a qualified disclaimer is a formal refusal of an inheritance that, when properly executed, allows the disclaimed property to pass to the next beneficiary without gift tax consequences. It can also reduce the disclaimant's taxable estate, thus affecting inheritance tax planning within elder law, estate law, wills, and trusts.